period. Burns me up, flies in the face of everything we should stand for. We will continue to cover this complete travesty of justice committed by the federal government, railroading and imprisoning these two border guards for shooting a drug-smuggling illegal alien. Proof of the total disregard for our miscarriage of justice by our government and absolute scandal and misuse of the law to further the erosion of the middle class in America. This week, our call to action is to contact Pastor Don Swartout and show our support for these two border guards that have been unjustly jailed by corrupt courts, an unprecedented case of judicial railroading. His phone number is 859-219-1222. His address is 3817 Land Ridge Drive, Lexington, Kentucky, 40514. Let's show some support. This man's a patriot attempting to do something to reverse this miscarriage of justice where these two men have got 11 and 12 years in prison. I'm not saying that there wasn't some possibilities, some misdoings on their part, but certainly they didn't deserve this kind of treatment. So I want us to stay on that subject. Feel free to call in if you'd like to comment on that. And while we're in the news, I would like to report some good news. The Supreme Court restores habeas corpus and strikes down key part of the Military Commission Act. We've reported on this before. If you're unfamiliar with it, the Military Commission Act, H.R. 6166, was a complete travesty to the Constitution of the United States. In a major rebuke to the Bush administration's theories of presidential power, and in an equally stinging rebuke to the bipartisan political class which has supported the Bush detention policies, the U.S. Supreme Court, in a 5-4 decision, declared Section 7 of the Military Commission Act of 2006 unconstitutional. The court struck Military Commission Act, struck down the section of the MCA because it was purported to abolish the writ of habeas corpus. This means by which a detainee challenges his detention in a court, despite the fact that the Constitution permits suspension of that writ only in cases of rebellion or invasion. As a result, Guantanamo detainees accused of being enemy combatants have the right to challenge the validity of their detention in a full-fledged U.S. federal court proceeding. The ruling today is the first time in U.S. history that the court has ruled that detainees held by the U.S. government in a place where the U.S. does not exercise formal sovereignty, Cuba technically is a sovereign over Guantanamo, are nonetheless entitled to constitutional guarantees of habeas corpus whenever they are held in a place where the U.S. exercises effective control. In upholding the right of habeas corpus for Guantanamo detainees, the court found that the Combat Status Review Tribunal's process offered to Guantanamo detainees, mandated by the John McCain-sponsored Detainee Treatment Act of 2005, does not constitute a constitutionally adequate substitute for habeas corpus. To the contrary, the court found that such procedures, which have long been criticized as sham hearings due to the fact that defendants cannot have a lawyer present, government evidence is presumptively valid, and defendants are prevented from challenging and sometimes even knowing about much of the evidence against them, fall well short of the procedures and adversarial mechanisms that would eliminate the need for habeas corpus review. Those grave deficiencies in the CSRT process means that there is considerable risk of error in the tribunal's conclusion. The court's ruling was grounded in its recognition that the guarantee of habeas corpus was so central to the founding that it was one of the few individual rights included in the Constitution even before the Bill of Rights was enacted. As the court put it, the framers view freedom from unlawful restraint as a fundamental precept of liberty, and they understood the writ of habeas corpus as a vital instrument to secure that freedom. The court noted that the freedom from arbitrary or baseless imprisonment was one of the core rights established by the 13th century Magna Carta, and it is the writ of habeas corpus which is the means for enforcing that right. Once habeas corpus is abolished, as the Military Commission Act sought to do, then we return the people to the pre-Magna Carta days where the government is free to imprison people. In its decision, the court emphasized and revived some of the most vital principles of our system of government, which have been trampled upon and degraded over the last 7 years. Our government was sadly using Guantanamo as a prison to violate everything America is supposed to stand for. We had no right to permanently detain people without trials. What a terrible precedent this sets around the world. Today I report some good news. The Supreme Court finally struck a blow for decency, for liberty, and to put a stop to the out-and-out tyranny being so brazenly flaunted by the Bush administration. We as a people should never accept this kind of total oppression of any semblance of civil rights to happen again by our country or in our country. If we ignore our civil liberties, they will go away. Our guest next week is going to be Russell Means, and he is the chief of the Lakota Indians. This is a story that's got absolutely no press, and I wanted to cover it this week so that when he's on as our guest next week, you'll have an idea of what's going on. Lakota Indians unilaterally withdraw from all agreements and treaties with the United States of America. We, as a freedom-loving Lakota people, are the predecessors sovereign of Dakota Territory as evidenced by the treaties with the United States government, including but not limited to the Treaty of 1851 and the Treaty of 1868 at Fort Laramie. Lakota formally and unilaterally withdraws from all agreements and treaties imposed by the United States government on the Lakota people. Lakota and the population therein have waited for at least 155 years for the United States of America to adhere to the provisions of the above referenced treaties. This continuing violation of these treaties' terms have resulted in the near annihilation of our people physically, spiritually, and culturally. Lakota rejects the United States termination by appropriation policy from 1871 to present. In addition, the evidence of gross violations of the above referenced treaties are listed herein. Lakota encourages the United States of America through its government to enter into dialogue with the Lakota regarding the boundaries, the land, and the resources therein. Should the United States and its subordinate governments choose not to act in good faith concerning the rebirth of our nation, we hereby advise the United States government that Lakota will begin to administer liens against real estate transactions within the 5-state area of Lakota. Lakota, through its government, appointed the following representatives to withdraw from all the treaties with the United States of America based on the Vienna Convention on the laws of treaties entered into by force in 1980 and the UN Declaration of the Rights of Indigenous People 2007. Where this is coming from is the UN, of which the United States government put such stock in, passed a resolution in September 2007 basically saying if a country conquered a nation or basically overthrew their society, those people have a right to reclaim their territory and live separate from the overtaker. The Indians have been treated horribly by our government, and now it may appear they will get a chance to reclaim some of what may well be rightfully theirs. I find this story to be very interesting. This is a large area, and these people are withdrawing from the United States. This gets absolutely no coverage by the mainstream media. Here is Russell Means, the president and the chief of Lakota Indians, will be our guest next week, and we will be following this story. I think everyone will find that very interesting. We're going to do one more story, and then we're going to take a break, and when we come back, we're going to go to what's happened this past week on the Michael Reagan show. The White House has declared that there is no information on any ongoing judicial processes concerning the hundreds of kidnappings and murders of American citizens by Mexican drug cartels and gangs between 2005 and 2007. Cybercast News Service specifically asked Press Secretary Dano Perino last Friday for information pertaining to a still operative travel alert issued by the State Department. The State Department's issued a travel alert warning everyone how dangerous it is, which warned travelers that violence equivalent to military small unit combat